I see a red button.
It's live.
Good morning. It is January, Friday, the 22nd of January, 2021. This is Senate Judiciary Committee. This morning's topic is civil trials and how that is impacting. We talked last week about criminal trials and the impact on the system. And this week we're talking about civil trials, looking at any legislation that we might do that would help move this process along, recognizing that COVID-19 has created more of a backlog than was already there. I think we're well aware that there was a tremendous backlog in civil cases before COVID-19 hit. Now it's been exacerbated. So our first witness is Christopher Maley, representing the Vermont Association for Justice. Chris, take it away, please.
Hi, this is actually Greg Weimer. I'm starting in front of Chris today.
Okay, Greg. Okay. Well.
So I am the chair of the Bar Association's Practice and Procedure Committee. And Terry asked me to appear today to give you guys some anecdotal evidence of how this backlog is affecting the practice. And I'm also, by happenstance, on the Bar Association's COVID-19 committee. And we recently did a survey with the bar, feeling out some of these issues, and we got some interesting results. I will say, out of 2,200 members, roughly, we had only 275 responses or so. So it probably doesn't qualify as a scientifically valid poll, but I think it still provides some interesting anecdotal information for you to consider. So with respect to the economic impact, 55% of our respondents reported that they've had an adverse impact on cash flow and billable work as a result of the pandemic. We didn't parse out exactly how much of that would be related to the lack of jury trials going on, but I suspect that it does play a pretty significant role, for anyone who litigates. Obviously, with the courts in their current condition, it's going to impact their overall ability to, process cases and get work done. Additionally, about 30% of the law offices reported receiving the payroll protection plan loans, which I think is another indicator of, the kind of impact that's been taking place. In terms of their attorney well-being, 70% reported feeling isolated, and about 60% reported feeling worried or afraid. And I think that, it's important to keep in context not just the lack of jury trials, but the overall effect that this is having, because I think that plays into the overall practice of law here. We did receive some individual statements from people who took part in the poll. And some people are really, the gist of it is that some people are really struggling to cope with this. And so I think anything we can do to help, get cases rolling through the courts in a more normal fashion, the sooner we can do that, I think the better it will be for the overall health and welfare for the bar at large. My personal anecdotal experience with the practice has been that cases are obviously languishing, and it brings to mind the old adage that justice delayed is justice denied. My experience has been that the process of working a case through from soup to nuts in terms of discovery has certainly suffered because there's no feeling of pressure for parties to get things done in a timely manner. So I've seen a real drop off in the lack of prompt responses to discovery requests. I think it's a case where, if you have a task, it expands to fill the available time. And I think that's one of the situations here, is that people don't feel that pressure of knowing that they're on a court docket that will be called. And so cases tend to stretch out a bit more because of that. It's certainly not more efficient. And I think, in terms of cases running longer, it ultimately is going to cost the clients more to get things resolved. I don't think that this is a situation where solely plaintiffs are harmed. I think there's also some harm to defendants as well in civil cases. For example, interest rates on known damages continue to accrue at 12% a year. And that's really through no fault of any party. It's just the fact of the matter is that cases aren't getting resolved.
Could you please expand on that 12% a year and the interest rates and how that impacts litigants?
Sure. So take, for example, in a personal injury case, if a person has a known and quantifiable amount of hard damages, such as medical bills, prejudgment interest under the statute begins to run when the case is filed, and the statutory interest rate amount is 12% a year. So the longer these cases take to resolve through no fault of the parties, that interest continues to run and will be collectible ultimately when any judgment is rendered. So that's a potential problem for litigants, that they have to incur that expense through no fault of their own. So I'm not sure what this committee is considering in terms of a resolution. The Vermont Bars Association's position is essentially that we understand the problem, we think it's significant, but we do have a lack of consensus in the members. So we don't propose a solution ourselves, but we're very interested in hearing, what a thoughtful review and a potential resolution might look like, so that we can present it to our membership and see if we can form some kind of consensus to get behind that. But we are very much interested in trying to get this.
With all due respect, sir, that's pretty useless. You want us to, I was trying to hold a hearing today to hear your solutions, not, and the Vermont Bar Association. You come to us with a problem and we've tried to resolve it. E-file, for example, we have a bill in here to deal with it, but to ask us to, who are not practitioners of the law, for our solutions, I was hoping that you would offer not you personally, but the Vermont Bar Association had some suggestions. And I was hoping that the Vermont Association for Justice had some suggestions. And I was hoping that the court had some suggestions. So I kind of take offense to the idea that it's that we have solutions. If you have any thoughts on how we could solve this problem, like having jury trials in alternative locations, for example, the Berry Auditorium, if it's deemed to be appropriate, that sort of thing is what I was hoping to hear.
Certainly comment on that. I have seen instances in other jurisdictions, such as Florida and Texas, where they have gone to remote trials. And so there's potential there for either a hybrid trial where the attorneys and clients could appear in court with sufficient room and space to be safe, and have the jury voir dire take place remotely. And that way we wouldn't need to have as many people in the building at the same time, and then proceed with the trial and have the jurors participate remotely. That would, I think, take a certain amount of economic support, because the potential jury pool would have to have access to sufficient internet services and computer equipment to be able to appear remote. But that is something that other states are looking at.
That's very helpful. Does the CARES Act fund, or the original, I don't know what's left of the Judiciary portion, but and the latest one may have money that we can use as well. So that's what I had in mind. I appreciate that suggestion.
Yeah. And there are, I think it's going to be a try and see approach to see, maybe try a couple of different alternatives and see what works smoothly. Maybe have a sample project proceed with one trial and see what lessons can be learned from that. I think some of the potential pitfalls of that approach is it's obviously not the same thing as having a jury during a trial where you can observe their mannerism as a group. So there are certain things that some trial lawyers might not find appealing about that. but we have to balance that against the fact that trials aren't taking place at all. And we have to find a way forward.
Joe, did you, Senator Benning had a question.
Yeah, so
Or
Greg,
comment.
I'm a criminal defense attorney and have been doing it for 37 years, so I understand things mostly from the criminal angle. But it occurred to me when you spoke about doing things remotely with a jury, I can understand voir dire as long as we've got the technical support to back up a voir dire situation. But when you actually get to
Would
the
you say what
place-
that is, Joe?
Yeah, that's when a large group of people is brought to the courthouse and then they go through a process of being picked for a jury panel. So
Okay.
if you consider the large group of people as the jury pool, from that pool, there is a small group of people that end up on the jury panel itself after they've been questioned by the respective counsel. But in the jury pool situation, that larger group of people, the technological hurdles could be fairly substantial just to make sure, for instance, here in the Northeast Kingdom, it's anybody's guess as to what your access for internet is, number one, and whether or not you have equipment that's got a camera and a microphone attached to it is another problem. But it occurred to me the other day that as these waves of vaccines are being implemented, what do you think about the possibility of taking the first wave, those 75 and up, and developing a pool from that group? I know there are other problems that might be associated with that, but I'm just asking you to roll that around in your head for a while.
Sure.
To think about how do we proceed, because this is going to be an avalanche when we are all finally vaccinated and we get back to normal. And you know from your work in the civil arena, and I from my work in the criminal arena, there are so many cases on the back burner right now. We've never seen anything like this. So when this avalanche happens, I would prefer it to be a smaller sized avalanche if there's a way to get from here to there in some piecemeal fashion. And it just makes sense to me that as you develop these waves of people who are immunized, there's got to be a way, as long as the court staff are also immunized, and that includes the respective lawyers, that you begin to minimize that avalanche later on down the road.
Right. And I think that's an interesting concept. One of the things I've read from other jurisdictions who have done these proceedings remotely is there is sometimes a question as to whether or not you're actually getting what the law would consider a jury of your peers, especially in the criminal realm, where you're limited to having people with the economic resources to have sufficient internet and computer equipment to be able to be in the jury pool. There may be a similar question as to your suggestion here, using people who are in that first tranche of people getting vaccinated who would be in the 65 to 70-year-old category, whether or not that constitutes, strictly speaking, a jury of peers. So it's a potential issue, but I think under the circumstances, it might make sense to move forward in that capacity, as you say. Otherwise, when jury trials start again, there's going to be such a backlog, there's just no way to work through them. And it's going to be a 2 to 3 year period to work through the backlog alone. So I think in terms of what potential solutions are, we'll have to compromise a little bit on what is the normal case, right?
Sure. In the criminal world, the parties could technically waive any argument about this not being a jury of my peers. I mean, I've got guys sitting in the jail right now. They don't care what the jury itself looks like. They need to have something happen so they can get out of jail. So I would envision that some of them at least would be happy to have a jury, a bunch of old folks. But the bottom line is we've got nothing right now, and somebody's got to start coming up with ideas on how to solve this.
Right. I think with an open and knowing waiver in court, where the defendants sign a waiver of that right in front of the judge and understand what they're doing, that I think that would be perfectly acceptable.
I assume it would be for civil cases as well.
Yes, I don't see why it wouldn't. But I just know anecdotally that the defense bar pushes back pretty hard on a lot of these issues, especially there's been talk of proceeding with 6-person civil juries. And there'd almost certainly be a challenge from the defense bar if that actually took place. But as I feel, my own personal position is I would like to see something done to address this backlog. It's just not tenable to have this continue. And by the time the general population is vaccinated, we're probably looking at another year before, the general population would be able to serve in a jury. So I think your suggestion is interesting and should be looked at.
I don't know what the backlog is in the civil arena, but I'm imagining it's the same as what we're facing in the criminal arena. There is, at this moment in time, if somebody came into my office and we decided they needed a trial, I've got to tell them it could be 5 or 6 years before that ever happens. We just have no way of dealing with it otherwise. And I guess I'll stop. I've made my point.
Yeah.
Senator Baruth has a comment or question.
I do think that's an interesting idea, Joe. I know that the committee is scheduled to hear testimony from the Department of Health on vaccines. One of the things I'm not clear in my mind about is apparently if you're vaccinated, you yourself are protected, but you can carry the virus still. So if we were to go on thinking about this idea, it would have to be not just the people on the jury who were vaccinated, but the entire, human infrastructure surrounding them,
That's
including others in the courthouse. And
I think I agree with that. As my understanding, and by the way, since you brought it up, Peggy has been working overtime trying to get the Agency of Human Services to meet with us on this issue, and we've yet to be able to establish a time. I know that Mike Smith decided that he wanted to be the one presenting to us, and obviously he just is in quarantine right now, so it's difficult for him to get together with us, but we are still trying to do that. But I do think that alternative venues, and I know the discussion in Windham County was they had 3 courtrooms, I believe, that they were planning on using, were criminal trials, and I think fewer jury members, like 6 jury members, if the parties agreed, or 8, whatever the number is, might help resolve some of these issues. Go ahead, Greg. I appreciate your time.
Sure. Thank you.
Any other comments from Greg?
I understand that the administrative judge has undertaken attempts to improve the ventilation in certain courtrooms that would help with what you just mentioned, to be able to proceed perhaps with smaller jury pools. And I'm not sure where that project is at this point, but I know that that was something that they had in their court reopening plan. And so I think if they can make progress with that and go with smaller jury pools, then perhaps that's a way forward as well.
Other questions for Greg? And Greg, you're representing Terry Corsones, is it that?
Yes, I'm in her stead for the Vermont Bar Association in my capacity as chair of the Practice and Procedure Committee.
Okay. I think go on to Chris Maley.
Great. Thank
Chris?
you.
Thank you, Chairman Sears. I appreciate the opportunity to speak before the committee this morning and talk to you about my perspective on the civil justice system right now. And when I say mine, I also include that of the Vermont Association for Justice, which makes up about 200 trial attorneys who are bringing claims in civil cases in Vermont, and more importantly, our clients. Greg talked a little bit about the impact on attorneys. I'd like to shift gears a little bit and talk about the problem for Vermonters and those I represent. The threat of a civil jury trial is the leverage that makes this system work. And we don't have that leverage right now on my side of the aisle. And so what happens is I make a demand, what's called a demand for settlement. In the vast majority of cases, the claimant, the Vermonter who's trying to bring a claim, is going to an insurance company and saying, we would like you to settle this case for X amount of money. It's fair trade value for the harms that your insured caused by their negligent conduct. And let's project out what a trial would look like and try to come to some kind of compromise. And that is a threat. That is a statement that says there's a next step. Right now, the insurance industry doesn't have any worry that there's a next step. We literally are asking them to make payments out of the kindness of their heart. And you can imagine how that works. We are at a stalemate. The message that I would like the committee to get from the plaintiff's bar is that the system right now is broken. And it doesn't mean that cases aren't settling here and there, but they're settling in a way that is unfair, that are lower values. They have no ability to push. And, you know, most cases settle at mediation. And I think mediation is a good answer. Trial is a last resort. But when you go to mediation, that process works because there is that next step to go to. And so now when you go to mediation and we're in Zoom, the mediator has a private session with my client, and the mediator says something along the lines of what Senator Benning just said. You want to go forward, right? Okay. We don't know when trial is going to happen. We don't know what it's going to look like. We don't know if hang on. You have mortgage payments, you have medical bills you can't pay, you have lost wages. Hang on. You should consider that in terms of what you're doing. And what does that do? What does that do to the system? So far, not good things for Vermonters. And my colleagues have the similar stories to tell. I talked to the most busy mediator in the state yesterday about this, and that's a conversation that happens in all these cases. And so there are jury trials in the civil system in Vermont are rare, but that's not the important piece as much as the idea that there is a calendar with a docket, with a deadline, with a jury draw. And as Senator Benning would attest, there are courts in the state that will put 15 cases on jury draw for a certain day. In criminal context, probably a lot more. And you'll look at that list and you'll say, there's not enough hours in the day for those cases to all be juries selected. But the judges know that the pressure associated with being on that list gets the parties to talk. All of a sudden there are compromises. All of a sudden there are resolutions. We don't have that. I have a case that was scheduled for trial in May. It has just languished. Nothing has happened other than an attempt for opening discovery again, for more work done on the defense side past all the deadlines have expired. And so what it means for plaintiffs is that they have no access to justice. What it means for insurance companies is they can sit on their money. They can have it in the stock market. They can earn the great returns, and they have no pressure to do anything. This is a boon for the insurance industry, pandemic, and in this arena. And so I'd like to pick up on Greg's part where he talked about that the VBA has a hard time with coming up with a position. Here's the real tension that's happening in Vermont. The plaintiff's bar says, let's do 6. Let's do 6 jurors. When Governor Scott lifts his, safety requirements and we can get back to work, the way we can get the wheels turning faster is to have half the amount of people in there. The court officers exposed to half the amount of people when the jury draws are happening, half the costs, and we can do this in a fair way. The defense says no. But the part that I want to leave the committee to be left with is that this is not a two-sided issue. The plaintiffs' bar are the ones that are trying to get in court. The defense bar are the ones trying to say we don't want to go to court. So this is not the bar can figure this out on our own. What the Vermont Association for Justice has advocated, I and Jim Levins wrote a letter to the Supreme Court saying, enter an order saying that now trials need to be done with 6 people. And I'm asking the committee the same thing. If a statute can be passed that says 6, then we will have a vehicle to move forward. There are some on the defense side that suggest that there's constitutional issues with a 6-person jury in a civil case. The Vermont Constitution does not require 12. It does not state that 12 are required. There are cases from Civil War era, 1860s and around, that say at common law, a jury in Vermont was made up of 12 men. Well, we have unprecedented times. We have an issue of safety. We have an issue of a backlog that's going to have legs, as people have talked about for years. And so that the 12 men idea needs to be revisited. And the Supreme Court has the power to do that. The legislature has the power to do that. We strongly urge that action be taken now. And for perspective, 6-person juries are not unheard of. They've been happening in Vermont in federal court in civil cases since 1973. I've tried those cases in federal court. I've talked to judges in federal court. They don't have a problem with 6-person juries. I think there are about 13 states that have 6-person juries in civil cases. So it would not be, moving heaven and earth to make that shift. The conventional thought on the defense side is that they would prefer 12. And I'm not speaking for the defense bar. There are some attorneys who have agreed to 6, as far as I understand. I haven't had that experience. In my cases, I've asked, let's agree to 6, and the answer has been Liberty Mutual says no. And they have the power to say no, and we can file motions with the court to see if the judges will grant that and force the parties to have 6. But that's what we're at. That's what the ask is today for this committee is get the discussion going about passing a statute or the Supreme Court entering an order. Senator Bruce, yes.
Well, no, actually, I do.
Oh, sorry, taking your role.
But I do have a question before.
Sure.
I have a question for Eric, actually, who's online. And my recollection is we did that bill a few years ago. I don't know where it went, but I thought we introduced a bill on smaller number of jurors. Maybe it was 8 and not 6. But my recollection is we had testimony on that a few years ago.
I think that's right. And I also think there's a significant question raised about the constitutionality under the Vermont Constitution. There's a couple of older cases, early 20th century cases in Vermont that specifically say that the jury right trial in the Vermont Constitution is for a 12-person jury. So I think there's concern about whether or not that's permissible. You could try it certainly, and let that, as I say, those are older cases. So maybe a resolution would be different today. That's certainly possible. But I think that came up as a significant concern.
Can you have somebody research to see where that bill? I do remember dealing with it.
Yeah, and I have those cases. I actually looked at this issue just a few weeks ago for in a different context, so I can send those along too.
I think I might have introduced the bill.
Senator Sears, there was also, I've been before, and maybe this is what you're thinking of, that there was a push and committee looked at it, including judges, and thought it was okay, and it never was passed, but for non-unanimous juries.
Yeah.
That was something that I talked
Oh, okay. Thank you. Yep.
So I don't know about 6, but we did discuss non-unanimous, and that did not, we still need 12 unanimous in Vermont. That statute never passed.
I don't mind having hearings on the issue. I think it's certainly related to COVID. Senator Baruch, you had a question.
And maybe part of it's been answered now, but I was thinking, and correct me if I'm wrong, anybody, if we pass a statute, it can still be immediately challenged. Then it has to go through the entire process, which takes us nowhere. So it seems like an order entered by the Supreme Court is the only thing that would really reliably speak to the problem in terms of time. Am I correct in that?
Can I answer that?
Yeah, please.
It would be challenged, but right away is, I don't know if that it could be described that way. I think what would have to happen would there'd have to be a judge who had a trial that went all the way through with the 6-person jury, and then the constitutionality of that would have to be questioned. There'd have to be some ripe issue. It couldn't be
But-
just as soon as the statute passed, someone says, we don't.
But
think
if I'm,
it's constitutional.
if I'm the defense bar and we've opposed 6-member juries and a judge and panels a 6-member jury, couldn't I ask the Supreme Court for a stay?
Yeah, maybe an interlocutory appeal. Yes.
Okay.
Yeah, and so I agree. That's why we wrote the letter to the Supreme Court saying, basically, in essence, if you're trying to weigh constitutional infringements, we have no trials now. And if you're demanding 12, we're going to have no trials for a long time to come. So is that a greater infringement on the Vermont Constitution to have no trials at all, or to have trials of 6? That's the question I'd like the committee to consider, and I think the Supreme Court should consider, because I think, not to steal Judge Grierson's thunder, but what I expect he's going to say is that the studies he has so far say the courts aren't safe for 6. Aren't safe for 12. I'm sorry, the ventilation. So the only way we're going to do them when we do open up are to have 6.
And then my last question is, it sounds from your testimony as though there's been an ongoing back and forth between the defense and plaintiff bars, to a certain extent, to the extent that you know what each other's numbers are. Have you explored the obvious middle ground?
Yeah, I'm open-minded to all thoughts, but I guess what I'd leave this committee with is the idea that the bar can work this out on our own without an order from the Supreme Court or without a statute. I just don't think is going to happen. I never say never. I've talked about Zoom jury draws. I'm open to that. I'm open to hybrid trials. I'm open to Senator Benning's thinking. Anything that can get the wheels going again, we have to keep an open mind about. These are not conventional times. So if we're talking about cases from 1860, they're not going to work anymore.
Pat Gable has a comment or question, and then Senator White. I think I see your hand up, Pat, and that's why I'm calling on you.
Oh, no, I didn't
Even
have
though
my
you're
hand up,
scheduled to
but,
testify. Oh,
right, I'm happy to wait till my turn comes.
oh, okay. I'm sorry. There's a hand. That was my hand. I'm sorry. I'm sorry. Senator White.
Well, Eric, are you going to give us the case that decided that it was unconstitutional to have less than 12? Because I can't find that anywhere in the Constitution at all. It does say unanimous, but it doesn't say
No, it
anything
doesn't.
about.
The Constitution, I've got, there's a couple of different cases that held it very
I
clearly.
think we got the cart before the horse here with all.
Okay,
I'll send you the cases.
okay, thank you.
The only other statutory fix I could think of would be, Greg mentioned that's interest rate. That's only on hard economic damages. I've never really thought that that was much leverage on our side of the table. So that means there's interest that runs on medical bills and lost wages, but for pain and suffering, loss of enjoyment of life, which are the larger claims, there's no prejudgment interest on those. And when I practiced in Massachusetts, when I first started, there is a statute that has 12% on all damages. And that does have some incentive to push a case forward. And Greg was mentioning that the defense are having to deal with the interest for no fault of their own. There's nothing preventing the defense from settling the case for fair value now or right away or at any time during a case. So it's not quite that simple, but we're open-minded to changes and ways to have jury trials, and we'd like to consider that discussion. And there was some mention about the COVID relief money. Obviously, there's going to be a need for resources. If we have challenges with technology for those in the Northeast Kingdom or elsewhere, it sounds like money is going to be a way to have to deal with some of that. This is not a problem that I want everyone to think of as an emergency problem that is going to be removed with the vaccine, that we're just dealing with a backlog for a couple months and then we're going to be okay. I think of this as a problem that has legs for years and that our fixes should be ones that we consider to be ones that are going to be permanent and help the system go forward. Thanks.
You. Next, Pat Gable, or are there any other questions for Chris? Pat or Judge Grierson, whoever wants to go first. Or,
Yeah, I'll
together?
start. Judge Gerson and I
Okay.
spoke, and then I'll turn it over to him. This is obviously, good morning, everybody. It's a very, very important discussion. We've spoken about a couple of issues in the committee this morning. Senator Sears, you opened with a very important question, which is what is it that the legislature can do to provide relief, which I will make a recommendation on that in a minute. Also, there were comments about well-being of lawyers, and the Supreme Court, which has as part of its constitutional responsibility the regulation of lawyers, is deeply concerned about the well-being of lawyers, not only for themselves and to make sure that the people who appear in court are well and healthy and able to represent their clients, but also on behalf of clients. And so that's another issue that the court is paying attention to. And then ultimately, some of these issues, which really do cross constitutional boundaries. And so in answer to the question, what the legislature can do, the best, most important, most direct, and most constitutional thing the legislature could do would be to actually appropriate funds to the judiciary for additional permanent positions in the judiciary that would address the under-resourcing that we've experienced for many years. As some of your committee members know, particularly those who might sit on government operations, the judiciary is very nimble and has ingenuity, and we've found different ways to deal with the issues of insufficient human resources to deal with our needs. But in the wake of the pandemic, and not just during the pandemic, but as Attorney Maley said, for the long aftermath of the pandemic, it's human resources. That's who we are. We don't own buildings. we have people, and they know how to either hear cases or support the people who hear cases. And so of all the constitutional responsibilities that have been talked about today in the committee meeting, that is so clearly a legislative competence and a legislative power, which is the power of appropriation. In another format, or maybe in another committee, or at another time, I can go into that in more detail. But that is by far the clearest, purest thing the legislature could do. On a second issue, and that is on what is the role of the court, what is the role of the legislature? It would be helpful just very briefly for me to identify what's happened since March 13, when the Supreme Court declared a judicial emergency as a result of the pandemic. And as a result of that, the Supreme Court and I and Judge Grierson have met in the beginning, multiple times a week. It was daily for many months. And now we're meeting at least once or twice a week, focusing in on all the issues that you've been talking about this morning. And that includes the balance of interests between the need to provide public health and safety precautions to those who, by no choice, have to come and use our court systems, and at the same time, to make sure that the constitutional rights of Vermonters continue to be served. The court has never been fully closed throughout the pandemic, and we continue to use the COVID-19 funds to provide technological support. And so, for example, although Attorney Maley was saying there have been no trials, that's not true. There have been no jury trials. We've continued to hold hearings in cases using technology. And it's the combination of the technology and many people in the judiciary working 24/7 and many more non-permanent positions in the judiciary, partly through limited service positions provided by COVID-19 funds, partly through the use of temporary employees, and with great gratitude, the many retired employees who've come back to work as temporary employees in the judiciary, both judges and managers and staff, in order to help us make it through. And so I think it's important to realize that while the legislature has a broad concern, and in your case, in your committee for the criminal justice system, the Supreme Court and Judge Gerson and I and the teams with whom we work focus 100% of our time on the issues discussed today. And that has a meaning under our Constitution, because with 3 equal branches of government, the Supreme Court sits and has the same position in the judicial branch as the governor has in the executive branch, and as the speaker and pro tem have in the legislature. And so the administration of the Supreme Court, including this balancing of interests, is clearly within the constitutional responsibility and duty of the court. We work, as you know, in collaboration with the other branches, and the best way we work together is when we are cooperating together and doing problem solving together. And we welcome the opportunity with this committee to do that kind of problem solving. I think in a minute when Judge Grierson starts to speak, you'll hear that we're already under consideration in the judiciary. And I know this committee knows, but for those Vermonters who might be watching today, when the Supreme Court issued an order declaring the judicial emergency back in March, we continued, and the Supreme Court continued to amend that order as public health evidence presented itself, and as we had some experience in the judiciary working within the confines of the threats of the pandemic. And as a result of that, the Supreme Court has found ways to amend that order and to adopt other rules that allow as much opening as possible. Judge Grierson will speak in a minute about the trial that we had scheduled in Wyndham that was postponed as the statistics rose, but will surely be scheduled again. And so the combination of first looking at criminal juries and the constitutional rights that are there is one consideration. We have had discussions, and there'll be a meeting later today of the committee, which is not just of the judiciary, but of counsel and others, looking at the potential restart of civil jury trials as well. And so one thing I would ask the committee is to recognize that the discussions we're having this morning are taking place on a daily basis in the judiciary. So I'll conclude, because I'd like Judge Gerson to have enough time to talk about the nuts and bolts of what we've been doing together. But we share all the concerns of the committee, and I speak on behalf of the Supreme Court to say that they are on a daily basis constantly reviewing, looking at all the ways we can open access to justice and still protect the health of Vermonters.
Thank you. Judge Grierson, unless there's any questions for Pat Gable. Judge Grierson.
Thank you, Senator Sears, and thank the committee for inviting us to appear and speak on this issue, which obviously is interest not only to this committee, but to the other witnesses and all of the folks in Vermont who rely on the courts to remedy the issues that are presented to us. I would just, for the record, Brian Grierson, Chief Superior Judge, just ask the committee to recall my testimony last week when the question before the committee was criminal jury trials. Why haven't there been any? And I'll just remind Senator, the committee, but Senator Sears mentioned it. In the Wyndham Courthouse, we were talking about using literally 3 full-size courtrooms to conduct. It could have been a one-day trial. In other words, that's just I think the best example of the task that is before us to try to conduct trials, jury trials, whether it's criminal or civil. The same issues that have impacted and limited our ability to conduct criminal jury trials apply to civil trials, civil jury trials. And the overarching issue that we all know is the ebb and flow of this pandemic. I think it's fair to say that when this started almost a year ago, people were thinking, okay, we'll be in this for a few weeks, maybe a couple months, and then by fall, we'll be back in business. And that obviously has not been the case. The Wyndham Courthouse, we thought was our best opportunity to have a trial. If you go back to AO 49, you'll see that the Supreme Court gave a priority to criminal cases and juvenile cases. Criminal cases because of that detained population. And so our focus up until now has been on trying to restart criminal jury trials. The idea behind Wyndham was due in part, we thought that was our best opportunity to do a trial. But it was really, we needed to have one trial to understand what it means to conduct a trial, whether it's criminal or civil, in this pandemic world. Senator Baruth talked about the impact of vaccines. And what I'm hearing, what I'm reading about the impact of vaccines, it should not be viewed as a panacea to the problems that we're here talking about. Because as he mentioned, and my understanding is the same, is that vaccine will protect me, but it won't protect, there's not enough data to determine whether, even if I have the vaccine and I'm immune, that I cannot transmit the virus to the person next to me. So what I'm hearing is that even with the vaccine, until there's a large number in the population having this vaccine, that we're going to continue to have to maintain masking and social distancing for some period of time, even if we have the vaccine. What that means is that this is not going to be a short-term solution. It is something that's going to continue. So even with the vaccine, we have to look at what do we have for resources? How can we use those? I said a minute ago that the issues that relate to the civil trials are the same issues, a lot of the same issues that relate to conducting a criminal jury trial. But there are some differences, and that's obviously why this committee is here today. So I just want to highlight those differences. One of the other witnesses, I think Mr. Weimer, indicated that we have been conducting evaluations for airflow, air circulation within the courthouses, because that is key to being able to bring in members of the public for these proceedings in a safe manner. There are differences, and I think I mentioned it last week, and I'll just remind the committee, if we're talking about the state courthouses, the Bennington Courthouse, the White River Courthouse, Brattleboro, are all state-owned buildings. BGS has control over the facilities, and they're the ones that we're relying on to provide us the information we need in order to assess the appropriateness of those courthouses for conducting trials. But civil trials, for the most part, except in single jurisdictions like Orange or Lamoille, Addison, for instance, most of the civil trials are conducted in the county courthouses. They present different issues. Number one, we've retained the services of an engineering firm to conduct the studies there, and we have received studies on those county courthouses that have either a full HVAC system or at least a semblance of an HVAC system, air circulation system. And with those reports, for instance, I know we have them from Orange, Windsor County Courthouse, Chittenden, and perhaps one or two others. But the common thread in all of those evaluations at this point is that they are saying that we can only conduct juries with 6 to 8 people, meaning a 6-person jury with 2 alternates. That obviously limits the ability to conduct trials, as Chris has indicated, as well as other witnesses. So even if those courthouses are deemed appropriate to conduct trials, right now, unless I get clarification on any of these, we're looking at limiting civil cases to 6-person juries. From the judiciary's perspective, we're not in the business of choosing between plaintiffs and defense, one side or the other. But I think it's clear that at this point, if we're going to be able to conduct civil trials in the county courthouses, we need a remedy to the fact that right now there are 12-person juries. And there's only one way of getting that, or 2 ways, either by agreement of the parties to submit to a 6-person jury, or is there some action, legislative or through the Supreme Court, that can try to address that issue. And I'll certainly look forward to the research that Eric has done, or will be doing, to look at that issue from a statutory perspective. So that's one of the big stumbling blocks right now with the inability to conduct civil juries. I agree with Chris and with Senator Benning. The threat, if you will, of jury trials, whether it's in a criminal context or a civil context, is what drives resolutions. We've seen that just in the Wyndham court when we picked 10 or 12 cases that we thought might be appropriate for criminal trials. And some of those cases settled just because we started talking about jury trials. We're hoping, just to bring the committee up to date, we're still looking at late February, more likely into March, to resume in Wyndham. And we're looking at other courts, hopefully coming online after that, but with some of the same limitations. Each courthouse and unit has to present a plan to my office and Terry Scott's trial court operations and Pat of how they're going to bring a jury in, how they're going to circulate throughout the day within the courthouse. I mean, that's clearly what the issue is from a civil standpoint. I will tell this committee that later this afternoon, the Supreme Court Jury Restart Committee that formulated the plan as it related to the criminal dockets is reconvening to discuss this issue of how do we get civil jury trials started again. A lot of the work that was done in relation to criminal jury trials certainly will apply to starting up civil jury trials, but there are some other issues that need to be addressed. And I hope that one of the recommendations that I will bring to that committee is the possibility of a rule through the court for a 6-person jury. But that's what I think is going to take to move civil trials. And that's the problem we're all confronting. I will say this. Someone mentioned remote trials and remote voir dire. I have already put together a committee of judges, trial judges, to look at this issue of, we began with the issue of remote voir dire. Just by way of example, we also mentioned, and Senator Benning mentioned, the limitations on cell service, internet service in places in Vermont. And that's one of the reasons, for instance, in the Wyndham trial, as we were moving forward, pretty early on, we dismissed the idea of a remote voir dire, remote jury selection, because there are pockets in Wyndham County that don't have cell service. Having said that, this group of trial judges that I've put together will continue to look at that issue. And I think even in approaching that, we have to recognize, number one, we can't exclude jurors because they don't have adequate cell service or internet service. So even if we're looking at remote voir dire, we have to look at it as some people may be able to engage in that means, but we have to leave open the option for people to still come to the courthouse for that purpose. So I view it as a hybrid. The reason I think remote voir dire is important is, as we're looking at what we can do to remedy this, I think we need to look at solutions that will outlast the pandemic circumstances. If there's any silver lining to this pandemic from the judiciary's perspective, it is the increased ability to conduct hearings remotely. Now, we've been forced into doing it at this point, but there are many aspects of remote hearings that I expect will continue once the pandemic lifts. In order for us to learn more about what it really means to conduct a trial remotely or virtually, we heard of a number of trials taking place out in the state of Washington that were exclusively Zoom trials, virtual trials. And so we invited a couple of judges from Seattle area to come in a meeting, obviously a Zoom meeting, but we had one just this week with the trial judges to understand what they did and how they did it. They have shared a lot of the materials that they have used to be able to do that. So even though it would appear on the surface that we have not been able to move ahead, and that's true to some extent, we are looking at ways that we can move ahead. I don't know how realistic it is at this point to say we could conduct a trial exclusively remotely, but I believe there are aspects of it, and principally the voir dire interests me because that's the largest number of people that are involved in the jury trial process at the beginning. So if we can use a means, a remote means to reduce the number of people coming in to a courtroom, and we get down to whether it's 6 or 12 in a criminal case, that has been would be a substantial improvement. So remote voir dire appeals to me because I think it's something we can continue to use. And that's exactly what the judges from Washington were telling us earlier this week. Their experience has been, even when this is over, they would want to continue that. They've seen it. So there are parts of this, as difficult as it is, that we continue to explore those options. And we're going to hopefully put together a pilot, if you will, of remote voir dire. At least that's the discussion that is going on now within the trial bench to see, is that realistic? That's all I've got at this point.
Judge, I appreciate both you and Pat testimony, as well as Chris. Senator Baruth.
Thank you, Judge. I'm wondering, to go back to what Mr. Maley was saying. He was saying that the plaintiff bar and the defense bar would not by themselves be able to work this out. And so he threw out two possibilities: one, a statutory fix, and the other, an order registered by the Vermont Supreme Court. What would your thoughts just specifically be on the efficacy of any statutory fix that we might do, as opposed to, is it your sense that it should be left to the courts to work out?
Well, again, I guess I'd like to, see the research, do the research on the issue of the statutory framework. I think Chris and others commented that if you passed a statute to affect this and made it effective on passage, as you sometimes choose to do, it would be challenged through the court process. And it may very well be that if the Supreme Court decides to enact a rule, and maybe an emergency rule, to apply only during a limited time period, that same challenge would come into play. So I don't know whether one, in that sense, one is preferable over the other. But that's what I hope to explore with the courts restart committee, is the possibility of doing that.
But would it be theoretically faster in terms of the elapsed time that we would have to endure the challenge if the Vermont Supreme Court produced an emergency order? The challenge for that, am I right, would be shorter in duration possibly than a statutory challenge
Yes.
that would have, okay.
Yeah. I mean, but the very nature of an emergency rule is that, and
Yeah.
how long it lasts is always an issue.
Because I find myself, when I try to think about us stepping into this, it seems as though what we might inadvertently do is lengthen the amount of time that nothing happens. So that's one worst case scenario.
Yeah. Whether it's through legislature or even if the Supreme Court was so inclined, and obviously I do not speak for them, I would expect it would be challenged. I will tell the committee that there's at least two different groups that I meet with periodically from other New England states to discuss this same issue, and not that that's the benchmark, but all the New England states are struggling with this issue. The meeting this week, Rhode Island hasn't had any trials. I believe, I'm not sure about Connecticut. Massachusetts may have had a few 6-person trials. Maine is on hold. The rise in the numbers in New England since beginning in November have continued, and that has, for the most part, brought any trials that were going on to a halt in January. And people are looking at, is it safe to start up again in February? It's more likely March, I think, is what people are looking at, and that's why I was referring earlier to hoping to restart Wyndham. The only other thing that occurred to me as I was listening, Senator Sears mentioned the idea of starting up, why not take the Barry Auditorium, which I'm intimately familiar with, as a place to do trials. So again, I go back to the idea of in a year where resources are probably going to be limited for whatever the legislature wants to do, separate and apart from the problem that we're before you with today. If you stand up the Barry Auditorium for trials, then you've got to ask yourself, how many other places can we do that within the state? And if we stood up the Barry Auditorium, who's going to get trials there? Is it going to be criminal trials, civil trials? How do we weigh a case out of Windham County or Bennington County or Rutland County? Are they the ones that get selected to come to Barry for that trial? But more importantly, I'm hopefully looking forward to the vaccines certainly making a difference in what we feel is a safe arena to bring people into. It may take longer than some of us think, but outfitting a building like the Barry Auditorium for trials at best is temporary. And the question is does that kind of investment at this point in time make sense, as opposed to hopefully opening up these courthouses and putting in the improvements, airflow, circulation, to get the buildings that are at least designed already for courthouses. Even if we have to use 3 courtrooms, we know within those buildings where the jurors have to go and what the jurors need. So I'm not opposed to that idea, Senator Sears. It's just it's a completely different investment of resources that we would have to think about.
resources are always an issue. Matt brought it up, and I don't disagree with her. You know, sitting on the appropriations committee, and seeing how different interests vary, and constantly trying to figure out what is the priority. And having, you're giving I think you give the legislature a little too much credit for having access to the resources, because frankly, the administration is the one with the access. When they come back with a 0% increase for the judiciary, and the House does a 0% increase, and we try to do a 4 to 8% increase in the Senate, it hardly makes a dent, and I am aware of that. But our problem is we're competing, and with different interests, and so we may never be able to get where you want to get. But within reason, I'm happy to look at any proposals to improve both post-pandemic and current pandemic access to justice, Vermonters. So whether it be criminal or civil, and I've asked the question and can't get the auditor to do an audit of, what happened to the transport deputies when we stopped doing transports?
Well,
that was just a minor resource issue to me. What happened?
So I'll comment this way.
I mean,
Senator.
that's just one. We know you're doing it remotely, by and large.
But let me just take a minute to tell you, one of the projects we're working on is with that very issue, because of the location of our facilities are somewhat isolated from where the people were bringing them. In other words, some of you may know that the Marble Valley has been closed, at least for the detainee population. So anyone arrested in
Springfield.
Exactly. So Springfield is now the hub. And so DOC is involved in transportation, but more recently, to address the issue of transporting people from Springfield, we have engaged the sheriff in Windham County to provide transport from the facility back to the Brattleboro courthouse. So it's almost the reverse of what they were doing. And we're just barely getting that project off the ground. And if it's successful, then we may reach out to other sheriffs to see if that would work in other areas because of the location of the facilities. So it's a question, and I just wanted the committee to be aware that that's something we're working on to take advantage of that resource.
And it might be helpful to clarify that the transport deputies are not part of the judiciary budget.
Yeah.
Right.
At this time.
That's right.
Senator Benning.
Judge, I agree with you. There's no panacea here. I have a question first and then a comment. Is there a general rule on jury draw day? How many cases are placed on the calendar? Is there a maximum of some kind that judges generally understand?
What I found over my time on the bench, and more so since I've been in this position and traveling around to different counties, it's almost a cultural, it varies. For whatever reason, Franklin County, by way of example, on their jury draw day, criminal draws, they would routinely have over 100 cases on that list. Whereas in other counties, it's a more reasonable list. You might come in with 10 or 15 criminal cases on a jury list. So it varies, and that's all I can tell you. The civil trials are usually a much smaller number, but it wouldn't be uncommon to have 6 to 10 civil cases on a list. Whether you want to call it jury draw or the final pretrial, but it varies from county to county and docket.
So there's no general rule from
No.
your office that says X number is
No,
the max. So that brings up the overall question for me. It's useless to get more personnel into a system that cannot function while those personnel can't be in buildings that don't have proper HVAC, unless and until those people are actually immune. And this avalanche that's coming, if we are going to not have available some magical paintbrush that takes care of it all at the same time, has got to start being chipped away before it all comes at us at one time. And so I'm coming back to the idea that the more people we can get vaccinated, we have to start piecemeal at chipping away this avalanche. So getting court personnel immunized needs to be, in my eyes, at the top of the priority list for this branch of government to start getting back to functioning normally. If there is a first wave that has people 65 and older, the idea of having those people brought into a place where the court personnel are already vaccinated, that's another step in the right direction. Having the obstacle of buildings that are not HVAC proper is then eliminated. That no longer becomes a hurdle to moving something and decreasing the size of the avalanche down the road. And as more people come into that wave, the second wave, in other words, you're increasing the size of a potential jury pool. And I understand there would be requirements to waive that have to be addressed. The issue of, is this a jury of my peers? But you have to start this conversation somewhere. If you have clients that are coming into the building that have not been immunized, while I agree that's a problem that we have to deal with, it is a much easier thing to do to isolate them in the building, much the way they are currently today. If I walked into Caledonia's courthouse, there is now plastic that isolates me when I'm sitting at the defense counsel table. But that is not as threatening to the court system functioning as not doing anything at all and waiting for this avalanche to hit us. So I guess my comment is simply to say, we all have to be united in convincing the administration in getting this system to move in some fashion again, that the court system has to be on the top of the priority list in getting vaccines. I'm going to leave it at that. I'm just looking for some way to get this avalanche. It's coming, whether we like it or not, but the size of it can be decreased if we use piecemeal operations to combat it.
Joe?
Yes, sir.
Another thing occurs to me about this. We talked about, on one end, there might be dissatisfaction or a challenge because it wasn't a jury of one's peers. I think on the other end, if I'm 75 and over and I get vaccinated, and then I find out that I've essentially agreed to be in a very small pool for jury draw, as opposed to what I'm normally in as a citizen, I think you might have problems there too, because older Vermonters would say, even though I'm vaccinated, I don't want to go into a congregate setting because I'm 75. So I want to be vaccinated and go back to my house and not encounter a large group of people. Your idea, I think, now that I think about it, would greatly increase any 70-year-old Vermonter's chances of being forced by law into a voir dire situation.
Philip, I made the
Yeah.
mistake of saying 75. It's actually 65 and
Well,
over is the first way.
Same-
But let
same
me say, when you get a notice for jury draw as a prospective juror, you are able to make an argument if you feel you really can't participate in the process for whatever reason. And the judge gets to make a decision about whether your reason is valid or not. There are all kinds of potential hurdles that may make an argument that somebody puts out and they come up and be valid, and the judge says, all right, I'm going to exclude you. But you still have a pool out there that we can start to use to provide leverage against this backlog of cases.
No,
As
I
both
do
civil and criminal are the same thing. To get this backlog taken care of, you've got to have leverage from someplace.
No, I understand that, but in essence, I think you could unintentionally disincentivize older Vermonters who hear that if they get the vaccine, they're now going to be part of a very small pool for jury trials. So I think there's problems with any solution. You've brought forward a potential solution. I think it should be discussed, absolutely. And I think I heard Judge Grierson say that all of these ideas will go in the hopper. But I'm just saying there are unintentional consequences to designating a small slice of Vermonters as the only people who will be considered for jury trials.
I don't disagree that there will be hurdles. I'm primarily saying we have to get the court personnel on the top of the priority list, and that is a place to start the conversation.
I agree.
And as those waves come in succession, you increase the number of people available. That will eventually bring us to where we want to be, but just getting a pool of any kind together will provide some leverage to begin settling cases. And that's the whole idea, is to start someplace. That doesn't cost us any money, by the way. The legislature doesn't have a cost associated with that. This is when we get the vaccines, they're available. We have to decide who it is that's getting them first. I'm suggesting our first attempt should be, let's convince the administration that the court personnel and anybody associated with the court system on a regular basis should be at the top of the priority list. And we get that system beginning to move again.
Fair enough.
Eric,
Senator Sears, I wasn't sure if you wanted to wait on this, or did you want to hear for a minute on a moment on the 12-person jury issue?
yes.
Well, I'll just read this, the language from one of the cases. And I think, as Mr. Maley indicated earlier, and he was indicating the year 1869, that could have been a random excellent coincidence, or it could have been, he's perfectly aware of this particular case. But I'll just read the language because it's so on point. And it's the language that in the Constitution that the court is referring to is in Chapter 1, Article 12, where the Constitution says the parties have a right to trial by jury. And if you look at this case, the language says that, hang on just a second, I had it here. The word jury, as used in the Constitution, means a common law jury of 12 men, obviously gender neutral today, but at the time it used the word men. The Constitution does not require the legislature to provide for trials of issues or causes by jury, but the Constitution does require that the legislature shall either provide for a jury of 12 men for the trial of all causes before all courts which have jurisdiction of any matter or cause in which the issue is proper for the cognizance of a jury, or allow the cause to be carried by appeal to a court in which that mode of trial is provided for. So it's quite clear, but it's also quite old. that's an 1869 case. And again, in 1917, in a different case, the court said the jury referred to in these provisions is the common law jury of 12. So it's clear, but it's also two points leap to mind, I think. One, because they're such older cases, it's perfectly legitimate for the legislature to try and pass a statute and go with a different number and just, allow the court to reconsider that position because it's been a long time. That's not unusual. It's also, one might say, particularly since the court is referring particularly to legislative authority there, and it kind of goes back to Pat Gable's comments earlier. It might be a situation where, given the emergency authority that the court has issued Administrative Order 47 under, you could sort of see the court saying, pursuant to that order and pursuant to its own inherent emergency authority, given the current circumstances of COVID, yes, we recognize that those decisions are out there 100 years ago, but in light of this emergency situation, by rule, they might provide for a jury of fewer than 12 people, at least during the pendency of the emergency. That sort of seems also like a reasonable position that could be taken. So anyway, that's what I had. I thought it might be helpful for the committee to hear that now, since we were talking about the issue.
That's helpful.
Thank you.
Why don't, in the interest of moving along, what if we would it amend? I'm sorry, Terry wanted to make a comment and I missed that. Go ahead, Terry.
Oh, no, and I apologize. I was thinking everybody was done, and I just wanted to make a brief comment at the end. I had invited Greg Weimer as chair of the Practice and Procedure Committee, which is the Civil Docket Committee, assuming that you all would prefer hearing from a practitioner. But I did want to just indicate on behalf of the bar, I can state that the bar would definitely give its full support to whatever measures are implemented to move things along, whether it's Senator Benning's encouragement that court personnel be moved to the top of the vaccination list, the remote voir dires, whatever is decided upon, the bar, you have the bar's full support. The judiciary has been very good about involving the bar in the AO 49 developments. We went from weekly to monthly calls with Pat and Judge Grierson and the chief, and we have bar representatives on the jury restart committee. So we want to support whatever will move things along. One thing that hadn't been mentioned in particular with regard to the civil docket that I just wanted to briefly mention, with the moratorium on the landlord tenant and foreclosure cases for all of these months, when that moratorium ends, that's going to, I think, open up a floodgate. And in order to have civil jury trials while the civil division judge is dealing with this incredible backlog of the civil docket, one possibility might be retired judges for civil jury trials separately, which does involve the costs, which leads to Pat's point. The bar also would fully support whatever funding requests were made to again move the dockets along so that all of these Vermonters who are in limbo with their civil cases will have a chance for things to start progressing. So there would be that support as well. Lastly, in terms of the 6-person jury versus 12-person, as Chris and Greg have mentioned, there are competing interests, but the bar would definitely support a decision that's made so that people can know when they talk with their clients, here's the timeline, here's what the situation is. That's another area where there's been a tremendous amount of limbo in the civil docket, and Vermonters are suffering as a result. So those are just brief points I wanted to make where the bar can offer a consensus and support. And again, whatever we can do to help in this effort, we're at your service.
I appreciate that. So committee, maybe it's time for a little discussion. I would have no objection to amending a judicial rule or a piece of legislation that would be temporary in nature during the pandemic, that would establish six-person jury in civil trials, which gives us a place to begin discussions. And I also have no objection to, and I hate to put you through an effort, Judge and Pat, but I have no objection to seeing what you think the resources would need to be in order to accomplish that. Senator White.
So I wouldn't have any objection to that either, but I think that given the conversation that that Senator Baruth brought up about the speediness of it, if we did it by legislation, it is going to be August before there's any, I mean, we have to pass something, then the House has to pass something, then it has to go to the governor. It's going to be a long time. It seems to me that just a letter from the Supreme Court, and I don't know if that has to be by rule or if it can just be part of a judicial executive order, given the emergency situation. It seems to me that that is a speedier, that would get it going much faster than legislation.
Well, there is a thing called the Budget Adjustment Act.
What?
There's a thing called the Budget Adjustment Act.
Oh, no, I meant in terms of allowing the sixth person. I wasn't referring to the resources. I was referring to the fact that to allow a six-person jury trial.
Well, you could put the resources into the budget and put in language that the court shall promulgate rules or something like that. I don't know. Yeah. Philip?
So probably you've all experienced this as well, all the other senators. People will contact me and want me to unilaterally change something about how our pandemic response is going. And I always have to explain to them that the administrative branch, the governor, has most of the emergency power. And in this case, it seems to me if the governor and the Supreme Court together issued emergency orders that were interlocking, you would probably forestall a lot of the opposition or the challenges. But if we go at it unilaterally as the legislature, controlled both houses by Democrats, I think we open ourselves up for a much more likely set of long-running challenges. So I guess my own thinking about it again would be, as opposed to us trying to cobble something together that falls apart, if the Supreme Court and the governor were convinced of the efficacy of a six-person jury, then both of them speaking to that in their capacity with emergency power seems like the way to go.
Yeah. Because even promulgating rules takes a long time.
Yeah.
Well, judicial rules are a little different. Chris?
I just add one thing on the Supreme Court order. It would be the Vermont Association for Justice preference that happen as opposed to legislation for all the reasons that were described. And there is some historical perspective here. The Supreme Court had shut down trials before. It was before my time, but there was a moratorium on trials. There was a budgetary problem, and the Supreme Court said, we're just not going to have trials. And attorneys from my side of the bar brought an action, a petition, to try to overrule that emergency order, to say, Supreme Court, you can't do this. You're shutting down a constitutional right. And the Supreme Court showed that it has power. And it could say, we met what we said, no trials. And the same thing here, if the Supreme Court says we can do this, the only remedy would be a petition. And you'd be asking the same people who just said we can do this to say, wait, there's this case from 1869. Supreme Court can say, we just issued an emergency order. We say this is constitutional under these circumstances. So there's no question they have the power to do this. It's just whether that's what they're going to decide to do or not.
And if I might just add, I think the likelihood that the court will be considering this kind of action and act pretty quickly is high. And so I don't know if that makes a difference to the committee, but It's
Good.
within the court's areas of expertise, as Attorney Maley points out. And I think the court, has a similar view to the discussion today about the urgency of moving these cases.
Great.
Senator Nitkin.
Oh, this afternoon, as I understand it, Judge Grierson is meeting with the Supreme Court panel, and maybe this discussion we're having here today could certainly maybe spur them forward to do something with regard to the 6-person juries.
This panel, Senator, is the Supreme Court established a jury restart committee back in the spring, and it consists of some members of the Supreme Court. It also has representatives from the Vermont Bar Association. It has trial judges. So it's a mix of people that make recommendations as a result of the pandemic and the impact of that on court operations. So this committee of the Supreme Court makes recommendations to the Supreme Court. So that it's that committee that's meeting this afternoon, of which I'm on that committee, but so are other members of the bar and as I said, trial judges. So it'll, and I would almost be sure that some members of that committee are listening to this session.
So I want to kind of, Senator Benning had a comment.
Yeah, I agree that this measure will move us in the right direction, but it's absolutely useless if you don't have a jury pool available on the other side of the conversation. And so I'm hoping that the message that's being delivered from us to the judiciary is the judiciary needs to be behind contacting the administration and saying, in order for us to achieve this objective, we've got to start raising on the priority list the personnel who are necessary to achieve what we're trying to accomplish here for vaccination purposes.
Well, I'm not an expert on vaccination, but I think what I've heard here today is there's a concern that until a large majority of Vermonters and visitors are vaccinated, you're still going to have the danger of the pandemic. And so I'm not sure how long this judicial emergency will last. The question is there a way for us to encourage the startup of 6-member, 8-member, I don't know, jury trials so that the civil backlog can start to get moved forward? And what would be the resources needed in order to do that in terms of technology, et cetera? And can they be part of the second, I'm going to call it CARES Act, that the federal government just sent out? We're looking at the resources, or perhaps a third one that the Biden administration has been talking about. But for my purposes, at least, I'm happy to look at the resources you feel you'd need in order to accomplish this.
Senator Sears, you hit on an important issue because the judiciary did get CARES Act funding, and we have already spent or embargoed the funding that we received. And so we would be happy to take a review of the pandemic-related needs in terms of doing a startup of jury trials again and provide some information to you. And that is kind of a separate issue from, the longer term issues regarding additional permanent positions, but we could work on that and then provide the committee some information on that.
That would be helpful. And in light of the budget adjustment that'll be coming out of the House in the next few weeks and being dealt with by the Senate Appropriations Committee, might be a timely place. But there are also the internet resources and stuff that Senator Benning spoke of, and others, whatever that might be. Senator White.
So I actually support Joe's position here on trying to encourage the administration to, because if you have, and the vaccines aren't going to eliminate the need for social distancing and masks and all that kind of stuff. But we need, if we're going to start up and figure out a way of starting up jury trials, we need to make sure that we protect the court personnel that are working and that have to be there. And it's for their protection that they're vaccinated, not necessarily for the protection of others. But I think that that's really important. And I know that each of us has heard from constituent groups that are advocating that they be at the top of the list. But and I understand the reasons that the administration is doing it the way they're doing it. But I do believe that if we are going to have a judicial system that works for the benefit of Vermonters and it gives them fair and speedy is, I guess, kind of a not a very good term, but it's relative. But it does seem to me that we need to protect the court personnel, that we cannot, and I'm for one am happy to join Joe in trying to convince the administration to put court personnel at the top of the list.
For the committee's information, I tried to testify about this a couple of weeks ago, but I didn't have good internet. The Chief Justice and I did reach out to executive branch leadership, it seems like 3 or 4 weeks ago, and we were referred to the Department of Health, and we are waiting to be contacted by the Department of Health.
Here's the problem that I see in us getting involved in that, frankly. And I don't necessarily disagree with Joe or Jeanette, but so you have a situation where most people would like to get vaccinated and get ahead of the list of those over the way that the state has rolled it out, plans to roll it out. I'm in New York State, they did a thing for teachers, but they forgot the childcare personnel. So they're all upset. Why are teachers more important than us? And I think it's fraught with problems, trying to get one group ahead of another group. So what about anybody who's a potential juror? Shouldn't they all get it? And it's just, I just see that. I think, I'm not sure we solve this problem until there's herd immunity. And frankly, it's the federal government, hopefully, is going to get more vaccine to more Americans as soon as possible. And that's the way out of this, in my opinion. So I just think there's problems if we try to do that. What about the jail guards? What about the prisoners, which is one of the highest groups nationwide? So it's various groups. I just
if I could only chip in, Dick, if we're waiting for herd immunity, every other suggestion that's been presented here is just that. It's a suggestion that's not going to decrease the avalanche that we're eventually going to get hit with. And the jury pool right now could be assembled with people 65 and older once that cohort is vaccinated. So you've now begun to crack that really tall iceberg. And to me, it makes sense that the judicial staff necessary to assemble that cohort is also protected. It's a finite group of people. And that system, in order to begin, has to have comfort that the people who are in these buildings that we all know are not properly HVAC'd have to have themselves the protections that are necessary to begin to chip away at this. if we are waiting for a panacea like herd immunity, I agree with you, that would solve the entire problem. But if we're waiting for that, we are just increasing this problem in proportions we all don't have any ability to understand.
My concern is, how do you get somebody to the top of the list?
Governor makes
noise.
the decision.
Huh?
We
Just-
make noise. We
The
become the
governor
squeaky
makes the
wheel.
decision.
I
Yeah.
would like to weigh in on that. I mean, teachers who are in the classroom every day, exposed to all kinds of kids from all kinds of families. I mean, they've been asking all along, and even though they are younger and therefore not such a risk of dying, which is what the governor says is the prime thing, is to keep people from dying. I mean, they still, it seems like everybody is desperate to get schools fully opened so that children can be in school, so people can go to work, et cetera. And I think, I don't see moving this group, and nobody's saying teachers are in any kind of line either. But
Alice, I would only push back to that statement by saying the governor right now is making decisions on who's on the priority list based on death rates.
that's right.
And I understand that logic, but this is a whole branch of government that is coming to a rapid standstill. And when that happens, it's got to be taken into account. It's not death rates that we're looking at. It's a whole branch of government that's not moving. And to me, that's a whole nother part of the conversation that has yet to be had. And it will require all of the people on this screen to be united in the belief that it's important enough for that branch of government to move forward, that the people who are involved in it get higher on that priority list. My wife is a teacher. I understand she has that need, but the chances of her running into a death situation are much lower than having a jury pool come in with all kinds of people from all kinds of age groups. If you don't get those people protected first, that's going to be an element that's a problem by itself. But the overall concern here is one branch of government is literally coming to a standstill. And I appreciate the fact that there are some things that are moving. Don't want to imply that we're dead in the water. But this avalanche is going to be incredibly problematic.
Judge Grierson.
Yeah, I don't want the committee to think that I was saying that we have to wait until we get herd immunity in order to move ahead with trials. Back in November, December, we were prepared to go ahead with the trial in Wyndham with or without vaccines. The vaccines weren't out there, as long as we maintain the proper social distancing and masking. And that's still the basis on which we're going forward. What I was saying was that it's those elements, the masking and the social distancing, will continue for some period of time. And that's the way we plan on moving forward.
I don't know. I don't have an easy solution this morning, but I appreciate Eric's research on the laws regarding the smaller. I agree with the majority of the committee who said that we we should encourage the Supreme Court to consider smaller juries than 12 for civil cases, and that we should consider alternative venues. I don't know if that was brought up, but I still think that's an opportunity in some communities. And there's a huge gymnasium at Southern Vermont College that's now owned by the Southern Vermont Hospital. It could be a resource in my community, for example. And I think pretty good ventilation, as I understand it. So there would be, maybe one of the things we need to do is consider alternative venues. In Bennington, there are 3 courtrooms, but I don't know how the structure would work for that. I guess Wyndham is a little better. But I think we also have to be willing to say that some cases from Bennington County need to be heard in Windham County, some cases from other counties need to be heard in other counties without signaling that we're doing away with the Bennington County court system. And maybe we can't use,
We need all the courtrooms we can get, Senator.
but maybe we can't use at this point in time, I'm thinking of the Bennington courthouse for civil trials. That may not be an ideal situation that would be able to be used in the near future. And who knows what the new normal is going to be. I mean, but I think there's general agreement that we need to get back to at least moving the backlog forward. And so if it takes a consensus of the committee, and Eric can draft something as a consensus of this committee to send over to the Supreme Court, I'm happy to do that. But it sounds like you're already considering these options.
Yes, Senator, the Supreme Court and the committees that advise the court are actively considering the issues we've discussed today.
I like Joe's idea of having the governor also be part of that executive order. I don't know if that makes a difference or not, but it certainly seems like it would have more weight, or a lot of weight, with the public anyway.
Why don't we take a short break till 10:30 and get back together at 10:30 and discuss this and some other issues?
Shut your video and audio off.
Thank you.
Honey, and I gotta go brush my teeth and go to the bathroom. I haven't had a chance. No, I'm going upstairs for a minute. Okay. If that's okay. No, 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 nothing. No.
I just went out and shoveled. There,
Wow,
that felt better.
that's multitasking.
Wow, I just needed to get outside.
Yeah.
You're a
fresh
better
air.
man than I, Dick.
Well,
I'm just leaving mine if it's 4 inches or less and I can drive through it.
oh, I didn't shovel. I just shoveled the walk.
Oh, okay.
I have a deck around the house. I just shoveled that.
I've seen many photos of your deck.
Thank you. Yeah.
Philip, if I line my screen up just right, you and I are side by side. Looks like we're sitting in the same room.
Yeah.
It's pretty much,
yeah.
yeah. I suspect there's a few different books there, but
Well, we overlap in a couple of areas. Vermont history. You like, don't you like 19th century stuff, Joe? American?
Yeah, I'm primarily American history. I've got some World War II materials and
there was an interesting article in this morning's Bennington Banner about the
Campion?
no, about there's a the historic Henry Bridge. I didn't realize is where a battle with the Yorkers took place. No blood was shed, but it was the beginning of the Green Mountain Boys, Hiram Ethan Allen. The Yorkers were trying to take the land away from the Breckinridges, who had settled just across from the bridge. There's evidently a sign there, and that was in July of 1771. So it would be the 250th anniversary this July of that so-called battle, but no blood was shed between the Yorkers. It was a posse of 200 Yorkers. And it's an interesting article. I don't know what they're going to do for the celebration, but it's kind of fascinating piece of American history that happened right around the corner from me.
And how much land do you have there, Dick?
A little under 2 acres.
Okay.
My own personal land, but it was all Benning Wentworth's fault.
Yep.
Yeah.
No, I'm just scoping out new places to go metal detecting. That's why I'm asking.
But actually, that area would be pretty good. I would expect maybe some relics there left from the battle.
Joe, I used to have a metal detector, and when the girls were small, they'd have birthday parties and, have 10 or 12 girls come over, all 7 years old or 8 years old. And I would bury a big metal box with the goodie bags that you give out at a kid's birthday party.
Yep.
I would bury it outside, and then I would put sod over it and everything. And so you couldn't see it. And then I'd tell them we were going to go treasure hunting, and we'd hunt all over the place, and we'd pull up little cans and stuff. And then at the end, I would, find the big metal box that had the goodie bags in it. And it was like, they were just so amazed. It was incredible.
Oh, wow.
That's great.
Can I tell you my metal
You're-
detector story?
Just so you're on YouTube, by the way.
That's okay. When shortly after we were married, I was much skinnier than I am right now. And I have this huge gold band, and it's very heavy. And when my fingers get cold, it would slide off. So we were visiting my parents in Minneapolis, and there was about 6 feet of snow in the yard. And we got out of the car, and my hands were warm, and I got up and I went like that, and my ring flew into the snowbank. And of course it was warm, so it went right straight down. My sweet husband went and got a metal detector and he actually found it.
Nice.
Wow. So Chip Conquest told me that his kids had buried a bunch of money in a box on his farm. And I agreed to go down and look for it. And he never told me that his wife had also lost their wedding ring. So when I got there, she pointed that out. I never found either, but as I'm going through the field looking for his kids' stuff, I said, Is there any possibility that one of your kids came back at a later time and dug it up and just never bothered to tell you about it? It's a fun hobby.
All right. So to summarize where we're at on the issue of the civil trials and criminal trials, I think Eric, hopefully the folks will take back and try to ask the Supreme Court to look at the issue of whether or not there should be jury trials of 6. That it would be better for them to promulgate that than for us to try to do it in legislation. That's pretty much the summary of the committee. Is there a desire to send a note on behalf of the committee to the executive branch as well of our concern about the startup of civil and criminal jury trials and the backlogs that we're looking at? Would that be something that you think might help?
I don't think it can hurt.
Can you do something like that, Eric? But
We just don't
Joe,
want to conflate civil trials and criminal trials with a 6-member jury panel.
no, obviously, no. You're right. But that at least to somehow look at alternatives and to that is a problem that needs to be addressed. And the executive judicial branches can perhaps suggesting to the executive branch that they help the judicial branch with the resources needed to accomplish.
Yeah, if that what you're asking me, Senator Sears, I could certainly draft up a letter from the committee that,
Yes,
suggested that to the court.
and to the executive branch, that the resources be available to the judiciary to help move this forward.
Who would be, any thoughts on who would be the executive branch recipient?
I would think Suzanne Young, the Secretary of Administration.
Right,
and
that's a good idea.
And Jay Pershing Johnson, the Governor's Legal Counsel.
Sounds good.
Are there others that you can think of in the executive?
No, I think Suzanne Young and the governor, and Mark Levine, I don't know.
Well, yeah, the Department of Health would certainly have a role there in terms of making sure that whatever we do is within the guidelines of the CDC or the DOH. Okay. Any comments from anyone? Pat Gable, Judge Grierson, Terry, or Chris Maley are still on the line.
No,
Senator, I just appreciate, and the judiciary appreciates the cooperation of the committee in addressing these really challenging issues. So we look forward to working with you on that.
Thank you. We do.
I don't have anything, but thank the committee and Senator Sears for your.
Terry, if there's any thoughts from the Bar Association on how to move this forward to, certainly they could weigh in with the court.
Great. And the judiciary has been great about involving the bar in the jury restart committee, AO 49 discussions, and we also so much appreciate your committee's work on this.
All right, with that, we'll move on to something else. More committee discussion of where we're at. 2 weeks into the session, and I feel like we've been here 2 months.
Right.
Maybe that's the result of Zoom, but for me, the biggest priority is if we're going to do something about good time, that we need to do that as soon as possible. Because of the fact
Earn
that
time.
Earn time, yes, thank you.
I would like to make sure that we also finish up both alimony and the competency issues.
I don't know if I shouldn't at least alert the Committee on Committees or the Rules Committee. They are not, it's hard to make them either one of them COVID-related issues.
You don't have to. The rules, I was told that it is the chair's discretion that some committees will be done with COVID related stuff, just COVID related stuff earlier than other committees, and that we have discretion to take up the issues that we feel are important to get done.
Can I ask Jeanette, is it,
Mhm.
and maybe this is a question also for Dick, is it your intention to try to move the compromise bill that we reached last year?
Yes,
That's the way it was introduced.
Okay, because as I noted before, I ultimately signed on to that and could absolutely sign on again. I wouldn't be excited about relitigating all from the beginning.
Right. No, if it's my intention is to just move what we did last year.
Okay.
that's S2, right?
Yeah.
S2.
Let's do is the alimony bill,
Yeah.
Yes.
whatever we call it.
S8 is sexual exploitation of children, which is the issue we took up at the end of last session. And we had a disagreement about whether or not the simulation means explicit depiction of any conduct described, if you remember the discussion. And the House is going to take that up, I believe. First, there's this bill from Senator Sears Baruth on that, which is S8. S11 is another bill that was passed last year in the Senate, but not acted on by the House, dealing with robocalls.
Yeah.
That I still don't like them.
So S25, the cannabis bill, I don't
Yep.
know how, we have started taking some testimony on the opt-in, opt-out question. And then we're also looking at the local commissions and boards, but that's as much as, that's where we intend to stop that. The bill is in here and we're going to then give our recommendations to this committee on those issues.
Is there interest in taking this up?
Can I just ask a question on that that came up on a call to me last night? If a town opts in, can they later opt out? Is that addressed in the bill?
Well, they can, but if they opt in and somebody sets up a retail establishment there and then they decide to opt out, tough. The retail establishment is there. They can't.
That's true. That's why I'm asking this question. So I just
Right.
asked the question that came up last night. If a town opts in, and this is something coming up because of town meeting, can they then the next year opt out? Yes, it would screw the business, but can it be done? I mean, is that?
No, it wouldn't screw the business because the business is there. They have the right to stay. They can't kick them out.
Is that addressed in the bill?
I
don't
think
think so.
that is
Under the new opt-in, can they then, if they, not something that's there now?
Well, that's the way it is now. And that's the way the liquor statutes are. If a town opted in, then they can't then opt out later. And close down the
But-
bar.
Could a town become a dry town? Is that, you're saying that's the comparison? Well, obviously,
They could have before a certain date, but then after that date, if they didn't vote positively to become a dry town, they automatically were not a dry town.
okay, so say they voted to become a dry marijuana town after they had opted in. What's the difference? I mean, that's, I don't want to get messed up in that here, but that's a question that is there.
You mean if they opt in?
They opt in this year,
Yeah.
you know, whatever they do, they opt in. And then later on, can they opt out?
Well, I suppose they could opt out, but they can't then close down any establishment that is there that was
Okay.
permitted under their opt-in clause earlier.
And then it's not the same as a dry town.
Yeah, it is. Because Putney couldn't vote now to become a dry town. That all ended in 1968. You either.
But if, so you're saying they aren't really then a dry town. Maybe you're saying a dry town in that no one new can open, but the old ones can stay in place.
Yes. They could do that. And it's only for retail, remember. All the others are allowed.
Yeah.
So, we will take up S25 at some point then. Probably after the 1st of February, I guess.
S30, Dick?
S25.
No, I was
Oh,
wondering.
what's S30?
That's the prohibited location bill.
Oh, yeah, we're already taking that up.
Okay, I just wanted to, I thought we were doing a sort of,
We are.
Round
We are. Okay.
okay,
We were talking about the marijuana
yeah.
fix bill. and
I
that's
thought
what
maybe
meant.
we had moved.
No, no,
Okay.
but that's fine. Yeah, S30 is gonna be taken up and decided upon somehow. But I have an anxious dog. Marley, stop it.
Need some doggy downers.
I need a doggy treat.
Just kidding, YouTube. That's the kind of thing the SPCA will then try to get me unelected.
You're in trouble now.
Can I ask a quick question? Does anybody know anyone from the hospital association or the medical association to testify on S30?
Yeah, I do.
Can you email me?
Wish
Yeah.
I could afford to send him to doggy daycare every day.
Thank
that
you.
We're on Zoom.
Peggy, I'll send you another, there are a couple of other people who have contacted me. I'll just
Great.
send you a little list.
Well, one of the issues that I wanted to raise, instead of just hearing, was do we want to hold a public hearing? Mike
No.
Barron.
No.
No. I think it's hard enough to hold public hearings in the best of times.
Yeah.
And a public hearing on Zoom, I think would be pretty difficult.
Especially given that you'd have to make the invitation widely available, and the possibility or the likelihood that somebody tries to disrupt would go up pretty significantly, I think.
If you're not going to do that, let me just suggest that ample opportunity for certain other groups be given
Mhm.
to have representatives of some kind, because the last thing you want to do is try to pass a bill like this in a Zoom setting and then get accused of nobody listened to us.
I
I
agree. I agree. I think we're gonna face that anyway. But I agree with Joe that we should do it that way as opposed to, if we did a 3-hour Zoom hearing, I've been at every one of the public hearings. They've been uniformly angry and sometimes threatening in nature. And over Zoom, people feel more entitled to express their anger sometimes rather than less. We also have only had one, as far as I can remember, only one breach of security, which was the agriculture hearing last year, where neo-Nazis got on and started putting Nazi paraphernalia up. You know, I just think the possibility for having a public Zoom hearing go off the rails is pretty high.
So
So,
if that's the case, and I agree with Joe that we need to give time for all sides to be heard.
Yep.
Peggy, is there a way that you or Mike Farrant or whomever can, and Joe, thoughts on this, or anybody's thoughts on this, is that we can reach people and suggest that each group would have an hour on Wednesday morning, whatever it is. The first Wednesday, and well, you know, I don't know how to, but how do you do this without, I mean, you're gonna,
if I can say
well,
that,
you didn't even let me finish.
oh, okay, I'm
Is there
sorry.
a way of providing that opportunity for each group to select 5 or 6 people to speak on their behalf? For example, the Federation of Sportsmen's Clubs, the Gun Owners of Vermont, the, what is the name of the group on the other side there?
Moms Demand Action, Gun Sense Vermont.
Yeah, those, like, if you pick those 2 groups and they were to give us a list of 5 names, with, you know, each, that would be 20 people.
I think
That's what I was thinking, Jeanette.
Well, if I can respond to that by saying that
Please do.
I think that we've heard already a number of people testify in favor of the bill. That, I mean, and if we have the hospital association, that certainly is, I think that if we have those people testifying, then they are testifying in favor of the bill. That counts toward that 1 hour that the pros get, I think. I think that it's a little unbalanced if we do it that way, because we've already heard from associations and people that support it. So I think we have to give more time to people who don't support it if they were going to do it that way.
Well, if I could, I guess I see Jeanette's point, but we didn't have any way of knowing how the statewide would fall out. We didn't canvass them beforehand. So the fact that the 4 statewide office holders supported the bill should not be subtracted from any time that average Vermonters have who are not politicians to talk about it, because then what we'll have is the politicians said this and the real Vermonters said that. And I don't think that helps anybody either.
Yeah, no, I didn't. But like we were just talked about Vaz testifying, and my assumption is they're going to testify in favor of it.
What's Vaz?
That the hospital association? Didn't Peggy just ask?
Yes, I'm just having trouble with the acronym. What?
Oh, Vermont Association of Hospital and Healthcare Systems.
Oh, okay. I've never heard that.
Yeah,
And
that's
I
Vaz.
think we asked the Vermont Medical Society, which is the docs.
Right. So those groups are groups that are testifying in favor of the bill. So if we,
Well, I don't know that.
I think we do.
Well, look, I'm want to make it clear to everybody. I'm not trying to stack the deck. I am happy. As I said, I've attended every public hearing where I've listened to 3+ hours of people expressing their views, often with fingers in my face. And I just take that to be the only way to proceed, is listening and hoping that people remain civil. So however the chair wants to work it out and determines it's fair is fine with me. I just want to make sure that everybody's heard.
Well, I think that the fairest way to do this is not, first of all, we're hearing from the groups that represent the impacted parties. the commissioner of DCF representing the licensed childcare facilities.
Yeah.
The hospital association representing the hospitals, the medical society representing the doctors. And that's the normal course. We could be accused of unfairness no matter what we do, but my idea would be to provide a morning, not next week, but the week following that, where each of those 4 groups are allowed a certain amount of time to present witnesses of their choice. If they want to just have one witness for 40 minutes or say 30 minutes, that's fine. If they want 5 witnesses for 30 minutes, that's fine. It seems to me a fairer way to at least allow the average member of those groups. It won't be the average Vermonter, it'd be members of those groups or people that they select.
That sounds fine to me.
That's what I would have in mind in lieu of a public hearing. Because I that way there, if something goes wrong during the Gun Sense Vermont portion, the person violates the Zoom rules, it's Gun Sense Vermont's issue. But rather than having, this seems to me that each group is responsible for whom they provide to us, and if something goes wrong, it's on them.
And, the only caution I would have is that I know Peggy is always, I think all the committee assistants are ready to kill the YouTube feed. And we should have somebody with their finger on the button. I think the way you lay out is liable to make it a very civil exchange, and I think that's good. But we would be opening it up more than we usually do with the invitations.
Yep.
So
Yep.
good to have somebody with a finger on the button.
Yep. And I think we'd have to make it really clear that they need to give us the names way ahead of time, because it was leaked out the other day, and during the meeting I had about 50 people trying to get in.
Oh, is that true?
Yeah, it was an honest mistake. But we definitely will have to know the names ahead of time, because I will only let those people in with the names that have been approved ahead of time.
Okay.
Just so you know, Philip, because you're not on the chair's meetings anymore, we've been instructed that if the YouTube feed is off for whatever reason, everything stops. The other thought I'm having here is the initial discussion about COVID taking priority. I see the expungement bill as a COVID-related matter to enable people to get jobs. So I don't want to lose that conversation if this conversation is going to take priority over it. I'm nervous about that.
I would flip the priorities myself. I see that expungement might in the future make somebody's ability to get a job more likely. I see S30 as a direct response to civil unrest that we've experienced during COVID, which is anti-masking debates that have merged with armed, threats at state houses. So if that's how we're creating a priority list, I would view S30 as more a COVID-related priority than expungement, which is good public policy, but it's something that we've been doing right along and will continue to do right along.
We'll have to disagree and agree to disagree on that one.
Yeah.
In any bill that we've taken up so far, I intend to hopefully have a vote on in committee, and if it has 3 votes, advance it to the floor.
Yeah.
So I don't think,
And
I was just, in terms of priority, the major priority to get done as soon as possible would be earned time, because of the situation that's created by it starting January 1st for that certain group.
How about the cannabis bill?
We can bring that up. And again, if it has 3 votes, that's kind of waiting on Senator White's committee. But I don't see that as, what we've had so far. It may be difficult because of Zoom to work on that bill.
We actually, I think that what we've been, the only part of that bill that we've looked at is the opt-in, opt-out and the
Right.
timing on that.
Well, I thought it
And
was,
we could, if the cannabis bill as a whole doesn't get taken up, now we could attach that to some other bill that, I mean, because that's a
Well, I don't-
municipal issue that needs to be addressed.
I think we committed that we would take the cannabis bill up this session.
Okay.
And I would also say, I think prioritizing is good. I've never been on a committee that's more efficient than this one in terms of passing bills.
Thank you.
It's true. So I don't have any doubt that whatever we put in front of us will finish. So, but obviously you have to schedule some things before others.
Probation is also, I think, but I don't, actually, I think they've done such a good job in the drafting. I think that would probably be really, there may be some controversy, but I don't think, I think the issues are fairly good.
Senator Sears, the other thing that I think is important to address is the issue of the public records requests and the juvenile cases and the public records issue. And
Yeah.
we're gonna work on that again on Tuesday and hopefully come to some resolutions about the role of law enforcement here. But I think it's important for this committee to do that in terms of and a lot of things came up from Pat Gable and others around that issue that needs to be addressed by Judiciary. And that is a pretty timely issue, I think.
It's timely, but it's also extremely complex.
It
Because
is
when you have
complex.
motor vehicle offenses,
Right.
Are they public or are they not public? If they're committed
Right.
by somebody 16
Yep.
or older. And so that's where I think, as we were going through those bills that raised the age, those were some of the areas where it was really tough to deal with.
Right. And we are looking at that, and there are
Motor
Commissioner
vehicle
Schilling
records
had some
public.
suggestions about how we deal with it, and so did Pat Gable, and different people have had different suggestions. And so we hope to come up with, there is no bill, but my hope is that GovOps can deal with the issue before it reaches the judiciary stage, the court stage.
Is everybody
And then-
familiar with the issue?
Huh?
Is everybody familiar with the issue?
You know, since we're on the public forum here, somebody should explain it.
The issue is when, since some cases can go either to juvenile court or family court or criminal court, when does a record become public if it involves a juvenile? And the media wants to have access to the records. But then if it goes to family court, then it's confidential. So, but it's already out there in the public. So that's the question about when, and many law enforcement, when there's an accident, if it does, they just say, I can't think of the term now, an unidentified juvenile or something like that. They don't give names. But the state police gives names immediately. And so there's some disconnect here about how that happens and then how you deal with the if it's a DMV issue, because those then become public. So that's the issue about why it's already public, but then it becomes confidential. So how do you address
your
that?
explanation of it is part of why it's so confusing and so
It is.
difficult because it really depends upon how the individual is charged. It's pretty easy if it's charged in juvenile, it stays confidential. But if at some later date it becomes a criminal case, then it's fairly easy. But what about an operating, a negligent operation, for example, of a vehicle, and you're 16 or 15 years old and you're charged
Right.
with that, because it's a motor vehicle offense that you're charged with, but it's also a criminal offense. What do you do with that? So that's
Right,
where-
and that's the only level we're dealing with is before it actually
But
gets
I
to the
believe
courts.
that it's
Is
mainly with
DMV
the,
and law enforcement.
and I remember dealing with this before, Eric. It was really, it was the motor vehicle issues. I think Rabbi was commissioner at the time when we were dealing with this, trying to figure out how to deal with the motor vehicle.
Nick, I've got to excuse myself. I've got a
Yep.
guy that's being extradited back to New Jersey I've got to deal with. So if there's anything else that pops up, I'd like to know.
Well, I don't think we've got much more, so we'll
Okay.
keep you informed. Good
Thank
luck
you.
with the extradition to New Jersey.
It's not me. It's not me that's going back to New Jersey.
Oh, rats.
Now, I'm from New Jersey.
Oh, no.
Right.
Typically,
Senator Benning, the same town.
Right.
other issues?
So did the rollout of vaccinations that was on the schedule originally, was that eliminated with regard to Jeremy Samuelson, the Deputy Secretary of Agency of Human Services?
Peggy has been working overtime, trying to get somebody from the agency to speak to us on the issue of vaccinations.
I see, okay.
And Peggy is welcome to give us a little update if she has one.
I was told early in the week that they wanted Commissioner Smith, and they were going to let me know. I told them we would work around his schedule, and they were going to let me know, but I have not heard.
Secretary Smith.
Secretary Smith, I apologize.
I have to say, the news coming out of the new White House about the vaccination situation is a little eye-popping in terms of what the Trump administration was saying was the case and what's turning out to be the case. So,
I agree.
yeah. So it may be that they have a good deal less vaccine than they thought.
Right.
One of the calls I had during the meeting is rather a lengthy call, vaccination, and that it's not going to this constituent satisfaction. I don't, it's hard to tell if it's the federal or the state or where.
Seriously, can I ask you a question?
Hold up. Who?
Can I ask you a question?
Yeah, sure.
A procedure question about running the committee, because we've run into this in GovOps, and I have prohibited the use of chat because in my mind, chat is sidebar conversations that go on. And if we were in the committee room, we wouldn't allow that. And the only way I allow chat use is if somebody refers to a document, and then Gail can post that on chat so that they have the link. So I just wondered if we in this committee have had any instances of that kind of chat going on, not the stuff on YouTube, but the stuff in the committee, in the Zoom committee, and what you do about it.
Never have. No, I haven't had a problem with it. Peggy sometimes sends me messages that, for example, Terry Corsones wanted to say something.
I noticed Erica Reddick yesterday was the first witness that I had seen send a chat. It was very small. It was just a quick comment, but generally I haven't seen anybody use it.
Well, I just announced at the beginning that it's prohibited.
I think can't Peggy shut it off? I mean, I'm not sure you want to do that, but I think that's an option when you're running the meeting.
I don't know if I
Yeah.
can, do that, and I definitely would like to be able to have the option to chat Senator Sears, just because there are some times that I need to let him know stuff.
Yep.
But
Yep.
maybe you could make an announcement that witnesses are not to use it or something to that effect.
Now, we
That's
could
what I do.
make a policy that witnesses aren't to use the chat.
No, or
I think
committee
it-
members.
Well,
We
but-
shouldn't be chatting with each other.
or with each other, no, but if you,
Who else would you chat with?
I don't know.
Well,
think-
the
Peggy
thing
and
about
I.
Yeah.
the chat is,
Yeah.
and again, I'm not sure I'm getting this right, but I thought the chat was permanent and discoverable. In other words, that our Zoom meeting is available to the public. And I thought, I was warned initially that the chats were also available to the public.
No,
Yeah.
they're
That I
not.
don't know.
Public does
They're
not
not?
see those chats. But like sometimes I also have to like chat Eric maybe about sharing a screen or something like
No,
that.
but I mean,
Me-
Peggy, in terms of a Freedom of Information Act, let's say, I think the chats could be discoverable to the public.
I think they could be too.
Yes, I think you're right.
I can ask Tucker.
Yeah, so it doesn't seem like an issue necessarily to me, but I think Jeanette's right to put it on the radar screen somewhere because we've got all these streams of information and we should not lose sight of any of them because they come back to bite you.
Yeah.
Somebody has an exchange that they think is private and then it doesn't turn out to be.
Yep.
No, it certainly shouldn't be used like you're passing messages,
Yeah.
handwritten messages back and forth, although I've seen it happen in committee.
Yeah.
Well,
Do
Yeah.
need to be able to communicate with Peggy too, I would think.
But this is one of the messages, got a call from Janet saying that Bert Saldi emailed her and said, you're going in and out and hard to hear you. Maybe you should speak a little louder. That's the
That's
type of chats that I get.
yeah, and I know that I have been on some, in our committee, it wasn't an
I think
issue, but we
I
did.
think until Peggy finds out, I would just discourage
Yeah.
witnesses and committee members for using chat to send messages.
I just say it at the beginning of every meeting.
But I don't want to ban it in case,
Yeah.
I didn't see Senator Baruth and his hand was raised and he was trying to get to me, especially when you're clearing the screen, I can't see everything.
Yeah.
So I'd rather have Peggy be able to notify me or
Mhm.
Senator Baruth say that I need to speak here first.
Yeah. I do think it's
So
important.
I think there's that type of thing is certainly permissible.
Mhm.
And there also was the conversation about the chat on the YouTube,
Yeah.
and that we have no control over, but I think that there was some discussion in the chairs meeting about disabling that.
Yeah, that was true. That's true.
Yeah. You can let IT know, Senator Sears, that you want that off.
Yeah, so far we haven't had another problem with it, so I don't.
I just wanted to bring that up as an issue that I think as we get more and more people joining us,
Yep.
that it could become an issue.
Okay. Well, thank you very much. Is there anything else before Eric?
Just a quick question. I think you brought it up earlier, Senator Sears, but I didn't quite hear the resolution of it. On S3, the competency to stand trial bill, I had a couple of House members ask me whether that was going to continue to be worked on in Senate Judiciary, and I assume the answer is yes, right?
Yes.
Okay, thanks.
Yeah, I think it's an important issue that needs to be addressed.
Mhm.
Okay. Have a great
Thanks.
weekend.